So before I get started, I want to thank you all for the work that you do. I was a history major in college, and I really appreciate the works of those who are trying to preserve our history. And for anybody who was here at the immediately preceding session, which was on 1960s architecture, I got to catch the tail end of that. I lived in a 1960 house. Until 6 weeks ago, it still had the original pink tile in the master bathroom, but master bathrooms no longer work when they're only 9 square feet. So, and I have something that's unique in terms of my house. It has an original 1960 tiki bar.
Oh, wow.
Complete with, I mean, there is so much bamboo in there. And it actually had the stuff they put on duck blinds. He had stapled that all over the ceiling so that you felt like you were in a thatch room. But after 50 years of collection of dust, the thatch came down last year. But it's truly an authentic tiki bar, really cool. Okay, but we're here to talk about open meeting law and running meetings. So what we're going to cover is the open meeting law and then just a little bit about running an effective meeting. Starting with the basics. So who does it cover? And it covers a broad range of public agencies, but the important thing for you is that it covers all committees or commissions of another political subdivision like a city. And I'm assuming most of you are local historic preservation commissions that are appointed by city councils. So it does cover the work of public bodies like historic preservation commissions. And the general rule is that all meetings are required to be open to the public. So then the question is, what's a meeting? And the law does not define what a meeting is. So the courts have defined what is a meeting. And in general, they've said a meeting occurs whenever there's a quorum, which typically is a majority of your appointed body. Whenever there is a quorum of the members present to receive information as a group, discuss or decide. So it's not just making decisions. If you even met as a group to receive information about something that would be coming before the commission, that would be a meeting and would be subject to all of the requirements of the Act. Now there are some exceptions. The court has said doesn't matter if there's a chance or social gathering, like you all happen to show up at the church social. Not a problem, as long as you don't discuss commission business. It doesn't apply to phone calls and letters in general. Phone calls, you would run into a problem if you were having a conference call of a quorum of the members, or if you were having serial calls where one calls the first one and says, let's do this at the next meeting, and the next one calls the next one. Those would be problems. Email can be a problem because if you reply to all and you start communicating about something that relates to commission business, and there's a quorum that's receiving that, and you're exchanging information, that could be a violation. And then lastly, there is, the legislature enacted a provision that allows participation on social media, as long as everything that's posted is posted for all of the general public to see. So there were problems prior to that with people setting up Facebook accounts. They would friend other council members, and then it was a closed group that was seeing this. So the legislature added a provision for social media, recognizing that many governmental entities have a social media presence now, but it does need to be public pages. So if you have a quorum present at some event that has not been posted as a meeting, what you need to do, and this will typically occur in two circumstances. One is it's the chance type of meeting. You just make sure that you don't discuss business. The second is you all show up at another publicly noticed meeting. Maybe it's a planning commission meeting, maybe it's a city council meeting, or a county board meeting, but it's something that is of interest to the commission and a quorum or more attends this other meeting. You're okay as long as you don't sit together, don't talk about what's going on, and you can't participate in the discussion. If there's a quorum of your body present and it has not been noticed as a meeting of your body, you can't participate in the discussion at that other publicly noticed meeting. So now, going back to the general rule again, the rule was if there's a meeting, it has to be public. So now what do we mean by what makes a meeting public? And in general, it needs to be within your jurisdiction. So if you are appointed by a city, your meetings need to be held within the city, generally. There might be exceptions, but if you had, for example, an excursion to visit some other site. But in general, your meetings would be held within the city. It has to be held in a building and a room that is accessible to the general public. So there was a case where a city was undergoing, City Hall was undergoing remodeling, City Hall wasn't available. This was a city council. They wanted to meet in a meeting room of an apartment building that had been offered for their use, but it was a locked apartment building. So they had to have somebody stationed at the front door to let people in and out. So it needs to be a room and building that's accessible to the public. The public that's attending the meeting needs to be able to see and hear the discussion. So there was an issue once where council was in session, but people came right up to the dais, and they sort of engaged in a private discussion with the council. They're in the meeting, the public's at the meeting, but they can't hear what's going on. That's a problem. You need to have at least one copy of your agenda materials, anything that's been distributed to the body in advance of the meeting or at the meeting. At least one copy needs to be provided in the meeting room for members of the public to review. You also need to provide notice of the meeting, and minutes are required to be taken, and votes are required to be kept in a journal. So I'm going to come back to what that notice, what those notice requirements are.
Corrine, may I just ask a question?
Yes.
So a number of the commissions sometimes have to go off-site, outside of the city council or wherever they regularly hold their meetings, to review a property. Maybe there's a permit that's been applied for to alter a building, and they need to go see it on site. So I'm presuming that they not only have to notice that they're going to be away from their normal location, but did they have to provide the exact location and then have somebody at that site to either welcome someone if they're coming, or exactly how does that play in?
Okay, because this is being taped, I'm going to repeat that question. I know everybody here heard it, but the question had to do with when you're conducting site visits and what notice has to be given of site visits at historic locations. If you're attending as a group, that is a meeting, and you will need to provide that same notice that the meeting will be held at this location at this time. And so, and you need to have somebody that will take minutes of the meeting. If you're conducting just individual visits, not a problem, there's not a quorum present. And so you don't have any notice requirements for that. You had a question?
That same site, if it's under construction, may not be either accessible or open to the public. It may not have been legally turned over or?
Right.
So,
For a site that's under construction and may not be open to the public, we do run into that once in a while. One approach is that if you're just conducting a tour, that you do it with less than a quorum. So that, and that if there's any presentation of information, that's done out where the public can hear what's going on, and then tours are conducted with less than a quorum so that and discouraging conversation. And that's just to make sure that you're complying with the rules, because mostly you're there for your eyes, to see what's going on. And then to the extent that any information that has been provided during the tour, if it's repeated in a public setting, that minimizes any potential claim. So, yes?
Well, I was just curious, how does this change if the committee appoints a subcommittee to go out?
Subcommittees. If we go back to that first slide, subcommittees are also subject to the requirements of the open meeting law. So then you get into the question of what's a subcommittee. If you have a committee that is formally appointed and designated, you are the subcommittee, and you have some decision-making power, then you are clearly subject to the act. If you we need a couple of people to volunteer to do this and report back to us, and they are not formally designated and not formally appointed, and they have no decision-making authority, and then they simply report back what they've seen, then those people who volunteered to participate would not need to comply with the open meeting law for purposes of whatever meeting they had.
So so we often do subcommittees and we assume because they're less than a quorum of the commission, they don't need to meet that, but are you saying that doesn't matter?
So the question had to do with committees, subcommittees, and when the subcommittee itself is less than a quorum of the commission. If it were a quorum of the commission, that would be a meeting of the commission. If it's a formally appointed subcommittee and a meeting of that subcommittee, whether it's 2 or 3 people, is, as long as there's a quorum of that subcommittee present, that is a meeting of that subcommittee.
And then what does formal appointment mean? Was that by council or is that just by the commission? The commission appoints the committee. Is that a
So the
formal?
question had to do with what is a formally appointed subcommittee, and that would be where the commission or committee designates this is going to be a subcommittee of our group. And if it is, formally has a name and membership, then that probably is a subcommittee that needs to be subject to the open meeting law.
How about if you're a liaison to, for this committee to, another event or organization within the community, so I officially represent this committee as a liaison? Is that, if I go, am I considered a subcommittee or something like that?
If the question had to do with where one person, one member of the commission serves as a liaison to some other group, in my view, that is not a subcommittee. You don't have any decision-making power. You are there to collect information and report back to the group. So you don't have any decision-making authority, so no. You don't need to worry about open meeting law requirements. Any other questions on that? Yeah.
Well, that ex parte, and you talked about going and visiting a property, we seem to have a little variance in that where some people say, I will not go there, I won't do anything but stand on the public sidewalk, I can't touch your property, or I'm trespassing. And then maybe the next person on another commission will go and talk and go over the whole application and find out all the stuff that's not in writing and then turn around and report that.
Okay,
So there's a real variety there of how do you visit a site?
okay, so the question had to do with site visits and what is permissible in terms of site visits. One had to do with, or one question had to do with, are you trespassing on property? And, well, that gets into a whole different realm. But if someone has made an are these situations where someone's made an
Yes.
application?
Oh, yeah.
That is essentially an invitation to visit the site, as long as you're not intruding on private spaces. So on every property, there's something that's known as the curtilage, which is the area that is generally considered open to the public, walking from the public sidewalk up to the front door. That's generally considered open to the public. You can do that. Not going in fenced areas unless you have permission. Not going, obviously, inside a building unless you have permission. But trespass doesn't actually occur. Legal trespass doesn't occur until someone, the owner, has told you, get off. And if you refuse to leave or you come back after you've been told you're not welcome, that's legal trespass. That's the issue of trespass. The other question had to do with ex parte contact, which is collecting information from an applicant, say, outside of the, whatever your formal hearing process is. That happens all the time. You do need to be careful about it. If you have a decision that's going to come before the body and you've collected information outside of whatever public hearing is required, you want to report that at the meeting. Because one of the things, and that's not, it's technically not an open meeting law issue, but it does tie in to one of the goals of the open meeting law, which is so that the public knows what influences there are on the public decision-making process. So reporting that information back and sharing it with the entire body is a good idea, but it's not necessarily inappropriate for one commissioner to go talk to the applicant outside. And in fact, we are part of a political process, and lobbying occurs in a political process. So, going back to the open meeting law and what it means to be public, in general, you're supposed to all be present. The quorum is supposed to be present in the same room, but the legislature has created a couple of exceptions. One is for remote participation by members through interactive television, which also includes Skype. So at least one person has to be present at the regular meeting place, and everybody has to be able to see and hear one another, and the public has to be able to see and hear the discussion that's going place. So you can have somebody who's traveling participate by Skype in one of your meetings, as long as you can meet all of those requirements. There's also provisions for participating by telephone or having a telephone meeting. That only applies if there's been an emergency or pandemic. So not likely to apply to the Historic Preservation Commission, but the law is there. So, notice requirements. I guess my first question is going to be the one that's last on this. Who handles the notice requirements for your commissions? Do you have staff liaisons from city staff, or are you, okay, everybody does? Then they're taking care of this. So this is just general information, and you don't need to worry about it too much, because they need to know this and need to make sure it's being done. But if there's a regular meeting, and you have a regular schedule of meetings, The only thing that's required is that be posted on the city bulletin board. And then you can meet at those regular meetings without any further additional notice. If you have a special meeting, you have to have 3 days posted notice, or you have to have mailed notice if there are people that have said, I want to be notified when you have a special meeting. The special meeting occurs anytime you change the date, the time, or the location of your meeting. So if you're doing a site visit, it might be at your regular meeting. If you're not convening first at your regular meeting location and traveling to the site and back, but you're convening at that location, you've now changed the location of your meeting, and you need to do that, notice that as a special meeting. You would not need to notice it as a special meeting if you're all convened at the right time and place, regular place, and then your agenda says we'll be traveling to and back, and then adjourning at your regular place. Because the public knows then exactly where they need to be, and then they can follow you. An emergency meeting, if there were a need for an emergency meeting, you don't have to give the 3 days notice, but you do have to notify the media in whatever way you can. Telephone, email, probably telephone. For a closed meeting, and it is not likely that you would have closed meetings. I'm going to go over when you can and when you can't close a meeting. But if you have a closed meeting, you have to follow the same notice provisions as you do for an open meeting. And then lastly, anybody who has actual notice of your meeting, at least 24 hours in advance, cannot sue for a violation of the act. So, question?
I deal with a town board, township board, and they continue their meeting, you know, they go till 11 or 12 o'clock and not finished, and so they continue their meeting.
Mhm.
Under what conditions do they have to notify, you know, the public about that they're a continued meeting?
So the provision on continued meetings, the question was what happens when a public body meets and then at the end of the meeting they continue it to a different date that's not their regular meeting date, let's say some other date, and what notice has to be provided. The statute only requires that the minutes of the meeting reflect that it's been continued to that new date, and as long as the minutes reflect that, then they've complied with the statute. So I think the onus would be on you, if they've continued a meeting, is to follow up with the clerk, the town clerk, and ask what happened, did they conclude the business, has it been continued until when? And the other thing is, if there are drafts of, this is a data practices issue, not an open meeting law issue, but if there are drafts of minutes, those drafts of minutes are public, and you can get copies of them even before they are approved. So they will note that they haven't been approved, but they are still public documents and you can get copies.
So the chicken scratching that I do on the agenda is also available? I throw that in the garbage afterwards, you know? I mean, it's just like little memories, things remind us, don't forget that.
You said the chicken scratching that you do on the agenda? Are
Yeah.
you the clerk?
I actually am the chair, but I'm doing the minutes too, which is why.
Oh, so you take the minutes?
Right.
Well,
Like who made the motion and all that.
that information, if that's the only record that exists, if that's the only form of minutes that exists, that information might be public. Once you've prepared the minutes, a draft,
Yeah.
you can toss those notes.
Oh, good, okay.
For now, I will say that there's some legislation that was introduced last year that was very broad in scope, and if it were enacted the way it was proposed, we would be keeping every document for a minimum of 3 years. But it hasn't been adopted. Okay.
Those are minimums though? Like if the organization decides to be consistent and post like further, like a week out rather than 3 days or something, that can be done?
Right, the minimum requirement is 3 days, it's at least, so you could post 5 days in advance, 7 days in advance,
Okay.
and that would comply with the law as long as you've done at least 3 days. So then, what else makes a meeting public? It's the agenda materials, that you have to provide a copy, at least one copy, in the meeting room of all agenda materials. If there are documents that are going to be provided to the public body that are classified as not public information, again, not likely to occur for a preservation commission, but it does occur for city councils all the time and town boards, then the data that's classified as not public does not have to be part of that public agenda packet. So closing meetings. The requirements for closing meetings are that all meetings that are closed must be tape recorded. And the tape recording has to be kept for the time limit that's specified in the law. There's already an exception. Almost everything I say, there's exceptions to, but the exception for taping all meetings is anything that's closed for attorney-client privilege to discuss pending or threatened litigation does not need to be tape recorded. All other meetings need to be tape recorded if they're closed. They need to be kept for 3 years unless otherwise provided for by law. And in the legislature's wisdom, they've added all kinds of different requirements for taping, some of which you kind of go, why is that different? But if they close to discuss labor negotiations, that has to be kept for 1 year after the meeting or the contract is signed. If they close for a security briefing, it has to be kept for 4 years. If they close to discuss the purchase or sale of real estate, the tape recording has to be kept for 8 years. Before closing the meeting, the public body has to state on the record the reason why the meeting is going to be closed and generally describe the subject matter. So meetings that can be closed, I've highlighted the ones that I think maybe in certain circumstances could apply to a preservation commission. Labor negotiations is not going to apply because I'm presuming you're not big enough to have your own employees. Those are going to be city employees. The city council will handle labor negotiations. Performance evaluations of employees, it may be closed. You may close for attorney-client privilege. And if there were a case where someone had sued the members of the Preservation Commission, you might have a need to meet with your attorney in closed session. Meetings can be closed for security briefings, but any financial decisions have to be made in public. And you can close to consider the purchase or sale of real property. There are other meetings that are required by law to be closed, and it would be a violation of the open meeting law to have these meetings open to the public. That includes any discussion of data that identifies victims or reporters of certain specified crimes, discussion of active criminal investigative data or law officer misconduct, discussion of health or medical data. There are some cities that they have municipal hospitals. Preliminary consideration of allegations or charges against an employee. That's only for preliminary consideration. Once the public body decides that discipline may be warranted, all further meetings have to be open to the public. So those are the meetings that must be closed. And then there are penalties for violations. There's a $300 fine for any member who intentionally violates the law. After there's been 3 adjudicated violations, meaning that court cases have been brought and a judge has decided 3 separate times that there were violations of the law, the member who committed those 3 violations loses their office, whatever that office may be, and also forfeits the ability to serve in any other capacity. If you're on a commission for a city, you could not serve on the city council or the planning commission or any other commission of the city. If you're on a commission for the town, couldn't serve on the town board, any other committee or commission for that town. And you forfeit it for the term of your office. So if you're appointed for a 2-year term, regardless of if the violation occurred, the 3rd violation occurred in the last of your 2-year term, you are out for 2 years. And then the person who brought the lawsuit can collect up to $13,000 in attorney's fees. The city or town, if you're associated with a town, may, but is not required to reimburse for those expenses. So it is something you could personally be on the hook for. So, any questions about open meeting law?
Will you cover later a little bit more about the ex parte talking outside the commission meeting and discussions?
Yeah, I can try. Ex parte communications, and I didn't. I don't have any further slides on that, so I'll just talk about that now. Yes.
Well, going back a ways, if you're at a meeting and there's a quorum, but you're not supposed to participate, not even to ask a question for clarification or whatever, you can't, you said you couldn't discuss, could you ask a question at least under those conditions?
Okay, I will, I'm gonna postpone your question for a second. This open meeting law question I'll respond to, and then I'll come back to ex parte contacts. So your question had to do with if there's a quorum of the Historic Preservation Commission present at a meeting that's already been publicly noticed, like the town board meeting or the city council meeting. And I said you can't engage in the discussion. That means no questions, no nothing, until the quorum isn't present. If you went and you were the only one there, you can ask all the questions you want because you don't have a quorum of your public body present in the room. But if you have a quorum present, if any one of you wants to ask questions or engage in discussion, you need to get somebody out of the room.
So kind of on that same vein, how about like a training or a conference like this where, for example, with Albert Lee, we have a quorum here. So not in this room, but during our larger discussions. And somebody's discussing, for example, talking about a project that's been worked on or something. How does that, if it's specific to what we do as a committee, you know, this is a conference for preservation.
In general, conferences and training on general subjects would not be considered a meeting of your commission. So you would want to be careful about getting into discussions about specific projects that are coming before your body. And if there were a quorum present, you'd want to be careful about that. But in general education would not be considered a meeting.
So the key,
Now,
the key would be projects we're working on that are in progress, and is that?
Right, projects that you're working on. Or projects that you know will come before your commission, specific things, you know. So now back to the question about ex parte contacts. Ex parte contacts don't really involve the open meeting law. The open meeting law is all about numbers. I mean, once you have a quorum that can make decisions, the goal of the open meeting law is to make sure that the public understands what influences have been on the decisions of their public bodies, and that those decisions are not made outside of public view. Those are the key aspects of what the open meeting law is aimed at, so that they know what their government is doing and why. Ex parte contacts comes in a different framework, and I'm more familiar with it. I'm going to put it in a city council context because I work with that more often. But there can be issues of due process. So city councils, under their zoning authority, will grant conditional use permits. Conditional use permits are for a use that is allowed in a particular zoning district, but only with a special approval and subject to specific conditions. And typically, they have to meet specific requirements that are set out in the city ordinance. When a city council is making a decision like that on a specific piece of property, the application of particular ordinance requirements to that specific piece of property, that's called a quasi-judicial decision-making context, as opposed to when they enact zoning laws, they're legislating. They're setting out broad rules that affect a broad range of properties and people, and rules that affect everybody in the city. In a quasi-judicial context, the city council is supposed to be an impartial hearing officer. And so an impartial, they are sort of like a judge, that's why we call it quasi-judicial, and they should not be subject to outside influences. So when there is a quasi-judicial decision that the body needs to make, the body could be attacked for any ex parte contacts, because now we have a public hearing process, but someone who's supposed to be impartial is having contacts outside the public view with one person who's interested in the proceeding and getting information that everybody else doesn't get to see, and that can be, in the right circumstances, that can be considered a violation of due process. So the case that attracted the most attention to that was one involving the city of Minneapolis, where one of the city council members was making a lot of pronouncements about a development that required a conditional use permit publicly before there had been any public hearing, and actively trying to kill the project. And the court said that person, that member of the council, was not acting like an impartial decision maker, because they weren't waiting for all of the facts to come out during the public hearing before they made a decision. And the court reversed it and sent it back and said, do it over, and do it over right this time. So that is the danger of ex parte communications, but it only applies when you're in that quasi-judicial context. And the way to mitigate it is disclose the context. Don't announce your decision in advance. Wait for your public hearing. Collect all the facts. If you've had communications with somebody outside the public hearing, disclose it. Now the public knows. So there has been no damage to due process in that context. That's the ex parte communication.
So then, when the HPC acts on a certificate of appropriateness on a building, is that a quasi-judicial function? I mean, sometimes we're talking about demolition, we're talking about, structural building issues, not just always exterior finishes.
Where the decision is specific to one property,
Yeah?
yes, that is probably quasi-judicial.
Okay.
So, and that just means you need to be You need to follow your process. If there's a public hearing process, don't be making decisions before you've gone through that public hearing process. The whole point of the public hearing is to collect all of the available information.
In that situation, is it appropriate for a commissioner to talk to a property owner and for two commissioners to talk to each other outside the meeting?
Yes. I mean, so the question had to do with, is it appropriate for someone to talk to the property owner outside the public hearing? Yes, it's gonna happen. I mean, especially when you're outside large, more structured cities like Minneapolis and St. Paul, you get into, I grew up in a town of 1,200. If the mayor wasn't willing to talk to you, the mayor's got a problem. You know what I mean? There is an expectation that you, but again, the key part is don't make the decision before the public process has been concluded. Respect the public process. If you take information and that information is repeated during the public meeting, you don't need to repeat it again. But if you get information that nobody else has heard and it is influencing your decision, tell people at the public meeting, this is what I heard, this is a concern that it raised for me, because then people who are opposed or in favor, whichever way that cuts, have the opportunity to respond to the information that's just been presented during the public meeting. It's all about due process, shorthand, fairness.
And then how about then with two commissioners discussing something that's coming up in front of the meeting, that's going to be coming up at the meeting? Can they have that discussion, or do they need to be concerned
Can
about
two
it?
members, can less than a quorum have a discussion about something that's coming up before the meeting? Yes. That doesn't violate the open meeting law because it's less than a quorum. Second, the Minnesota Supreme Court has recognized the need for lobbying and persuasion in public entities. Where it would cross the line is if two people were having a discussion and then they said, okay, we've decided how we're going to vote on this. Now, this person, you've got A and B meeting, B goes over and talks to C, repeats all this stuff. We've decided how we're going to vote. When you have serial meetings of less than a quorum, for the purpose of making a decision outside of public view, that is a violation of the open meeting law. And if you are in, again, this isn't the public open meeting law issue, but the due process issue, if you have a quasi-judicial decision that's coming up, you should not be making a decision even in your own mind and announcing that decision before you've heard all the facts. You need to be open to the facts that are disclosed as part of the public process.
So we don't have any city staff, okay, for our HPC.
Okay?
And so when someone, and the city just granted a $5,000 grant per property owner, so everybody's interested now. And they call me and say, Darlene, I want to put on a door. So we have everything online, but they can't figure out the forms and find it. So I make a copy and I go down there and give it to them and I say, I'll come back in a few days. And then they would, I help them fill it out. What do you want to do, step by step? And they sign the application and submit it, but I make no comment. For instance, we might put in 2 or 3 different colors for awning. What color awning do you want? Okay, and we'd make it flexible enough that the property owner can then come and change his mind or amend it at the meeting. Is that a violation?
No. So the question, this is a small commission that has no city staff to assist them, and the question had to do with assisting an applicant fill out the forms because they don't understand the forms. You haven't made a decision. You're using your knowledge, just like city staff would do, to assist the person in understanding what information needs to be put in this application, but you haven't made a decision And you don't have the authority to make a decision all by yourself. The application will be processed, it will come through the normal review, and your commission as a whole will make that decision. So, I'm gonna move on to running an effective meeting, because lots of times, I mean, we're all volunteers when we're serving in these capacities. And, yes,
Before I let you move on altogether, I know one of the things that troubles our commission is the conversations that take place before the meetings about that next item. You know, I really think that that's a good idea, and, you know, I'm upset that the staff report doesn't support that. But, so it's me lobbying another commissioner that I'm in favor of this, and I'd like you to be in favor of it. Is that a violation?
is lobbying a violation? No. The court decisions recognize, and now these were decisions that involved the city council, and I mean, Minneapolis, I think, even has caucuses, you know, because they're political, they have caucuses of their members. So the court recognizes that these are political bodies, and that lobbying and persuasion are part of what comes with that. So lobbying on a one-to-one basis is not a violation of the open meeting law. It's where there's a quorum or more that meets and discusses. Whether they're all in agreement or whether they all disagree, it doesn't matter. If there's a quorum participating in this discussion, then that's a violation of the law. And if lobbying takes the step beyond that to making a decision where less than a quorum communicates with less than a quorum, etc., in a series of meetings to make a decision outside of public view, that's a violation. But lobbying one-on-one is not. Okay, so the last part is just a little bit about conducting a meeting, and it's pretty simple. It's very important to have a good presiding officer, especially if you're going to be involved with contentious types of hearings. Somebody who understands how to preside over a meeting and has the strength to perform in that capacity is important. So the presiding officer is important. And one of the things that they should do is the key thing about hearings and public hearings is people just want to know that they were heard, and they want to feel that the process was fair. Most people, while there are exceptions, most people can accept that someone could come to a different decision than what they personally would like, as long as they feel that they were heard and that the decision was fair and the process was fair. So that's the key. And some of the things that will help that are making sure, particularly if you have a contentious matter that's coming up, announce what the rules are going to be before you start taking any public comments. So I've been in council meetings where the room was packed, and they knew everybody who was there was going to want to come up and give their own, presentation. And so they would set a time limit, and the time limit was 3 or 5 minutes, whatever it was. Announce that in advance, because if you let person 1, 2, 3 come up, they haven't exceeded 5 minutes. Person 4 comes up, and they're rambling on, and then you try to impose a 5-minute limit. They're not going to think you're being fair. They're going to think you're attacking them and what they say. So announce the rules in advance and fairly apply them. And when you're making a decision, If people have come up and they've made all kinds of, you know, reasons why you should or you shouldn't do something, acknowledge what they said and then say, but I think this is more important, or but I don't think that goes to whatever the standard is in your ordinance, but acknowledge what they said. That's very important because people want to know that they were heard. Nothing gets people more angry than when they come up, they make these impassioned presentations, public hearing closes, and the body says, move to approve, all in favor, boom, 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 there's no discussion, the decision's made, they don't understand why you did it, they think you just blew them off. Respond to what people have said. That's key. And going back to the presiding officer, having somebody who can do that, who won't get caught up when there are personal attacks, but who can calmly say, you know, call it to order, tell people we're not going to proceed until you sit down, announce the rules in advance, somebody who can calmly handle all of that. That's key if you're going to be in contentious public hearings. So then the last thing was, I had two handouts today. One is just a real simple summary of the open meeting law requirements. This is the guts of what you should know about it. And then the other one is a handout. I altered it. It originated with the League of Minnesota Cities, which if any of you have the League of Minnesota Cities on municipal issues and zoning and land use, wonderful resource. Their website's great. They have a ton of information, and they have a ton of information about meetings. They've got a mayor's handbook that could be useful to your commission. Anyway, so I got this from the league website, and I think I might have altered it and shortened it a little bit. In my experience, and I'm not going to tell you how long I've been doing this, but it's been a long time. We very rarely get into parliamentary snaggles. It really, parliamentary rules come down to good manners. Robert's rules is exceedingly complex. It was intended for large legislative bodies like the legislature, the state legislature. It's really not needed and not used very extensively at a local level where you have 5 or 7 people that just have to conduct business. So parliamentary rules basically come down to good manners. But this has a key. It tells you what motions can be made while there's active debate on a topic, and it tells you whether it's a debatable motion or not. So I'll just hit a couple of these, the ones that come up most often. So if there's someone makes a motion, somebody else wants to amend that motion. Maybe they want to add an additional proviso or clarify something. The motion to amend can be made while the main motion is before the body. You have to vote on the motion to amend first before you vote on the main motion, because until you know whether it's amended, you don't know what the main motion is. So you vote on the motion to amend first. The person who made the original motion is not required to accept the motion to amend. But if they do, and they say, I accept that as a friendly amendment, that means they've just revised their motion. You don't even need to vote on the motion to amend at all, because they've just said, I revised my motion to include that proviso. So now you know what the main motion is, and then you go back. A motion to divide a question, lots of times people will make multi-part motions. I move that we do this and direct staff to do that and do some third thing. Anybody, any other member can say, move to divide the question. Because maybe they agree with part 1 and 2, but they don't agree with part 3. So anybody can request that the motion be divided, and that is not debatable.
But do all these things require a second?
Yes, motions require a second, unless you modify your rules. In some cities, there are some rules of procedure for small bodies that don't require a second at all, even on a main motion. But people are so attached to it because they don't let it go. Anyway, a motion to call the question, that just means I want to end the debate and I want to start voting now. You have to vote on that motion to call the question, because maybe others don't want to end the debate. It's not a unilateral, we're ending the debate, I move to call the question, that's it. You vote on whether the question will be called, and then if they say, yes, we're calling the question, then you vote on whatever the motion is that's pending. The other one that comes up a lot is the motion to reconsider. And a motion to reconsider, and these are all based on Robert's rules, by the way. There are different rules of procedure. Another common one, fairly common, is Sturgis. Sturgis does not require someone on the prevailing side to move for reconsideration. So that set of procedural rules is different. But most cities in Minnesota follow Robert's rules, and under Robert's rules, the motion to reconsider can only be made by someone who was on the prevailing side of the motion that's going to be reconsidered. So, and it has to be done at the same meeting. So if you, early in your agenda, you hear something, you make a decision, and you move. Later in the meeting, somebody has said something else, in connection with something else. Wait a second, I think maybe we didn't think through this enough. If you were on the prevailing side of the first motion, you could move to reconsider. If that passes, the effect of that is that the thing you decided previously, it's back in front of you, as though no decision had ever been made. And you're back to square one. If it doesn't pass, then your previous action stands. What happens if the meeting ends and now the next week you wait a second, that was wrong, we shouldn't have done that. You can still address it, it's just called a motion to rescind a previous action, and that's the next thing that's on that sheet. Some things can't be rescinded. Once they're done, they're done. If you've made a contract, you don't rescind, you've approved that contract. Somebody has gained rights in that approval once that's been approved. But if they have not, if it's not gone too far, so that people have accrued rights in whatever decision you made, then you can rescind that action at a subsequent meeting. Any other questions about those sort of procedural things? Okay. Well, yes.
It's actually, I guess, bounces back to you're saying that it's being polite and about making sure the public's heard and that kind of thing. We had a situation where under, I think it's section 106, that we're invited as a commission to comment on a project. And the only materials that were distributed were the application and the findings of the applicant regarding the issues that we were supposed to consider or comment on. It wasn't a public hearing. We were only commenting as a commission, but we were voting at the end of the discussion on what our comment was going to be.
Mm-hmm.
And there are members of the public who were very, very upset about this and said, you don't have all the facts at all. You need to know about this and this and this. And the city attorney said, no, they don't have a right to give you any information. And if they offer it to you outside the meeting, you should refuse it.
Okay.
Now, I'm not asking you to disagree with St. Paul City Attorney, but does that make any sense to you?
It all depends. So the situation had to do with the decision that had to be made and the information that had been provided. It totally depends upon what your ordinances are. There is no right for the public to comment at a public meeting unless it is a public hearing. And so that statement is correct. If there's not a public hearing, there's no right for the public to comment. Many bodies will allow public comment even though it's not a public hearing, but there isn't a requirement to do so. And depending upon what the ordinance was, that ordinance could have limited the decision and the scope of the decision so that the information that the residents were trying to present wasn't relevant or wasn't appropriate. So that's entirely possible. But you should ask the attorney to explain further, because you should understand what your process is and what the scope is of the decisions that you're making. And the attorney should be able to explain it. Okay, yes?
If you're new to a board and you meet with a few different board members one-on-one on individual occasions, so it's not a quorum, but you're saying, hey, just can you tell me more about this decision and this and why the board did this and a little bit of history. Since you're meeting with, you're new, you're
Right.
finding to become more informed, does that fall under that repeated lobbying or the?
Yes, so the question had to do with if you're new to a commission and you want to meet one-on-one with different members of the commission to get an understanding of decisions they've made in the past, maybe relationships within the board, how they operate, how things work, that's not a problem. That's totally appropriate. Again, less than a quorum, and you are not trying to use that as a device for making a decision outside of public view, so that's fine. Okay, well, we're early for lunch. You'll get a run on everybody else, grab a good seat. But